Early on, my client tells me that she secretly recorded a conversation she had with the doctor soon after the wrongdoing occurred. Now, can I use that to ambush the doctor when I question him at trial? Would you like to know the answer? Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. So now, throughout the entire course of litigation, throughout the entire course of discovery, which lasts 2.5 years, we keep this fact a secret. We don't let the defense know that we have this video. We don't let the defense know that there's damaging information where the doctor basically admits that he screwed up and admits that his screw up caused my client harm and injury. None of that has been disclosed. Why? Because I and my client want to use it to ambush the doctor when we go to trial. Now, why do we want to go to trial? Because we believe, or at least my client believes, that by going to trial and the jury hearing this damaging information, they are going to get so angry and upset with the doctor that they are going to give my client so much more money than what she believes her case is actually worth. Is that the right thing to do? Is that the appropriate thing to do? Are there any repercussions for doing that? The answers are there repercussions? Oh, yes. Are there going to be problems with getting this piece of evidence into court when I go ahead and confront the doctor during cross-examination? The answer is, oh, definitely yes. Will the judge want to know why I did not share this damaging information with the defense during the course of discovery, despite knowing that we had this evidence from the very beginning of the case? You better believe the judge is going to want an explanation as to why we did not disclose and share this information when we knew about it and we had this information from the very beginning. Once the judge learns at trial that we have had this damaging video, this damaging admission from the very beginning, and we did not share this information with the defense, the judge is not going to be very kind to us or to our case. The judge is going to get upset and very, very angry. The judge is likely going to tell me that there is no more trial by ambush. Maybe 50 years ago that occurred, but nowadays, absolutely not. And the fact that we had this for such a long time and did not disclose it at the very beginning when we obtained it, that's a problem. The fact that we went through 2 years of discovery and now at no time did we ever share this discovery, share this evidence with the defense, that's a huge problem. In all likelihood, the judge is going to preclude me, to prevent me from asking the doctor any questions about what's contained in this video. The judge will likely strike any mention of this secret video that was obtained by my client during this hospital admission. And now that means that the jury is never to consider any aspect about this particular video or what's contained in it. They are not to surmise or conjecture or come up in their minds with what they think the video contains. Why? Because it will not and will never be admitted into evidence. Now, would that outcome be different if we had gone ahead and shared that at the very beginning of the case? The answer is absolutely. Would I be able to use this video, this secret video, to go ahead and cross-examine the doctor? Assuming that the judge believes this is admissible or about to be admitted, then in all likelihood I would have been able to ask the doctor many questions about it. However, if the doctor and his attorney never saw this video and never had an opportunity to prepare an answer or defenses about what's contained in the video, and never had an opportunity to evaluate that video when evaluating whether or not to make a settlement offer on this case, now the judge is not going to take kindly and he's going to prevent me from going ahead and using any aspect of the damaging information in that video. And there is also a very good possibility that I, as your attorney, will be sanctioned and fined for failing to follow discovery rules that requires that all proper discovery be exchanged with the other side during the course of the lawsuit. And if I fail to do that, and now only at the time of trial do I try and get this information introduced, the judge is going to be very, very upset. He's going to penalize me, he will likely penalize my client, and in all likelihood prevent me from ever asking a single question to the doctor about the damaging information that's contained in this video, which means that your hopes of destroying the doctor on the witness stand are gone. Your hopes of getting a jury to get so angry and upset with what's contained in that video are likewise all gone. So just because we have failed to disclose that to the defense, in all likelihood, this entire strategy is going down the tubes, along with the possibility that your case may go with it. So why do I share this quick information with you? I share it with you just to open your eyes and help you understand what happens in these medical malpractice cases in New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.